I want to tell you something before this case begins. He came in carrying a folder, thick enough, organized enough, tabbed and marked in a way that was meant to signal that what he was carrying was equivalent to what I was holding. It was not. I had read his filings, all 9 of them, before he walked through that door. I had looked up every case he cited. Several did not exist. Several existed and said nothing like what he claimed. What he did not know, sitting at that defense table arranging his documents with the care of a man who believes he has found the mechanism that unlocks the system, is that I was already holding the record, every piece of it, including a piece he had no idea was in evidence. I have been on the federal bench for 26 years. My name is Victor Lawson. I have seen this certainty before. Not this man, but this specific shape of belief. The belief that the right words, correctly assembled, can dissolve the authority of a federal court. What I have not often seen covered is what the judge in that room is actually doing while the performance unfolds. That is what this channel is for. If you are someone who wants the reasoning, not just the ruling, subscribe and hit the bell. That is the commitment this channel keeps. And before we begin, write one thing in the comments you want someone in your life to understand about how a room like this one actually works. One thing, for someone who needs it. The truth is this: he went to that stand, placed his hand on a Bible he had carried in himself, swore to tell the truth, and then he said he had never signed that document. He said, "I do not recognize the jurisdiction of this court, and I am not the person named in that indictment." I said, "You are in this courtroom. You are under oath, and what you just said is not a legal argument. It is the beginning of a problem." He said, "I don't consent to these proceedings." I said, "Consent is not required." Then he went to the stand. He placed his hand on the Bible he had brought himself, not the court's, his own, which he had carried in under his arm with the specific deliberateness of a man who believes the gesture has legal weight. He swore to tell the truth, and then he lied. I am going to show you exactly what that looked like, not the summary of it, the actual sequence, what he said, what I already had in my possession when he said it, and what the law required me to do. Because you have seen this kind of defendant described before. What you have not typically seen is what the judge in that room was doing while the performance was underway. That is what I am going to open for you today. He arrived carrying a manila folder, thick enough to suggest authority, thick enough that a person walking past the defense table might have thought it represented years of preparation. He arranged its contents before the session opened. Tabs, colored markers along the edges. What appeared from the bench to be a presentation organized by someone who had studied not the law, but the idea of the law, the aesthetic of a legal argument without its substance. I had read everything in that folder before he walked through the door, not because I had obtained it improperly, because he had filed it. Over the preceding 6 weeks, this defendant had submitted to my clerk a series of pleadings, 9 of them, each signed with a variation of his name followed by a colon and a set of words designed to indicate that he was signing as a natural person rather than as a legal fiction. Each one cited case law. I looked up every citation. Several of the cases did not exist. Several existed but said nothing resembling what he claimed they said. One existed, said approximately what he claimed, and had been overturned in 1991. I want you to understand something about that folder before I tell you what happened on the stand. The man who carried it was not stupid. He was not random. Someone had constructed this for him, or had constructed the framework and let him fill in the details. The pleadings had a specific internal logic. They cited specific statutes. They invoked the Uniform Commercial Code in ways that are recognizable to any federal judge who has seen this movement operate. He had been taught. He had been taught carefully. And whoever taught him had also taught him that the moment a judge took him seriously, really engaged with the theory, was the moment the theory had won. I did not intend to give him that moment, but I did intend to take the theory seriously. Because a legal argument dismissed without examination is a legal argument the viewer of this proceeding cannot learn from. And this courtroom, even with an audience of 1, is always a proceeding that someone needs to be able to learn from. What I want you to hold as I take you into what happened on that stand is the asymmetry. He believed he was bringing something I had not encountered. I had encountered this before, not this person, but this certainty, this specific shape of belief that the right words, correctly arranged, could dissolve the authority of a federal court the way certain combinations of words are supposed to dissolve contracts. I had encountered it, and I had watched it fail, and I knew the precise mechanism by which it was going to fail again. What I did not yet know was how far he was willing to go. The stand was about to show me. The charge against him was federal. I will not specify the statute in the way that identifies the case, But the essential question came down to a document, a contract bearing his signature, his date of birth, his notarized acknowledgement, executed 14 months before he appeared before me. The government had submitted it as Exhibit 7, 3 days before his testimony. He had been present in the courtroom when it was submitted. He had heard it described. He had heard his name read from it. Before he was sworn, I addressed him directly. This is not standard practice. Typically, the oath is administered and testimony begins. But I had read the pleadings. I knew what was coming. And the law requires, when a judge has a reasonable basis to believe a witness may not fully understand the nature of the oath, that the judge provide clarification. I told him on the record that the oath he was about to take was not a ceremonial formality. I explained in plain terms what perjury requires under the federal statute, a false statement made under oath, material to the proceeding with knowledge of its falsity. I told him the consequences. I asked him if he understood what I had just described. He looked at me for a moment with the expression I have come to associate with this ideology. Not hostility exactly, but a kind of patient tolerance, as if I were the one who had not yet understood the situation. Then he said, "I understand your words, but I do not recognize your authority to administer that oath." I said, "Your recognition is not required." I swore him in. He placed his hand on his own Bible, and his hand was steady. And he looked at the ceiling for a moment before he looked at me. And in that look, I saw something I want to describe carefully because it matters to what came next. He was not nervous. He was not calculating. He was committed. He had arrived at a place, through whatever path of doctrine and instruction had brought him to my courtroom, where he genuinely believed that the framework he was operating inside would hold. That belief was, in its way, the most important piece of evidence in the room, because it told me exactly what the testimony was going to be. And it was. His attorney, he had an attorney, or had had one. The attorney was present but had been formally dismissed by the defendant 3 days earlier when the defendant filed a motion declaring himself sovereign counsel, was seated at the defense table. He had not left. He was there in the particular way that defense attorneys are sometimes there at the end of a case they know they cannot save. Present, quiet, and very still. The direct examination was conducted by the defendant himself. I want you to sit with that for a moment. A man who does not recognize the court's jurisdiction, examining himself in a federal proceeding on charges that carry significant prison time. He asked himself questions. He answered them. The questions were structured to build toward a single conclusion, that the name on the indictment referred to a legal entity created by the government at the time of his birth, represented by his name in capital letters on official documents, and that this entity was distinct from him, the living, breathing man who could not be held liable for the entity's obligations. I let him complete this testimony. I want to be specific about why. This was not patience. It was not courtesy. It was the application of a standard I apply in every proceeding where the defense's theory is about to be tested against the evidence. You let the theory be stated completely so that when the record contradicts it, the contradiction is total. You do not interrupt a man in the middle of constructing the argument that will convict him. Then the prosecution's cross-examination began, and it was brief. The assistant United States attorney approached the witness stand, and she set a document in front of him, and she said, "I am showing you what has been admitted as Government Exhibit 7. Do you recognize this document?" He looked at it. I watched him look at it. The specific quality of attention a person gives to something they have already decided how to describe. He said, "I see a document." She said, "Is that your signature at the bottom of page 3? He said, "That is the signature of the legal entity I described." She said, "Is that your date of birth listed in the notary acknowledgement?" He said, "That is the date of birth associated with the legal entity." She said, "Did you sign this document?" And here is where it came. Here is the word that made everything that followed not only possible, but required. He looked up from the document. He looked at me. He looked back at her, and he said, "I never signed that document. Never." Not the entity signed it. Not I signed it under duress. Not I dispute the authenticity of the notarization. Never. A categorical denial. A denial that could not be reconciled with the document, with the notarization, with the date, with the testimony of the notary public who had been deposed 6 weeks earlier and whose deposition was in evidence, with the surveillance footage from the office where the document had been executed. Footage that had been submitted as Exhibit 14 and had been playing in this courtroom on a screen behind the witness stand while he testified that he had never signed it. He did not know the footage existed. That is what I mean when I tell you about the asymmetry. He came in carrying a folder. I was already holding the record. I want to tell you what I was doing in the seconds after he said that word. Not dramatically, precisely. I was applying the standard. Perjury, under 18 United States Code Section 1621, requires a false statement made under oath that is material to the proceeding, made with knowledge of its falsity. I worked through each element in sequence the way I was trained to, the way I have trained myself to do in 32 years of building reasoning that has to hold. The false statement was on the record. He had said under oath that he had never signed the document. The document existed. The notarization existed. The footage existed. The statement was false. The oath had been administered 11 minutes earlier. The oath was valid. I had administered it myself. Materiality. His signature on that document was the central element of the government's case. His denial of that signature was not peripheral testimony. It was the core of his defense. The statement was material. Knowledge of falsity. This is where I want to be precise, because this is where the reasoning required the most care. I did not assume he knew the statement was false. The ideology he was operating under had, in a certain distorted way, prepared him to believe that the statement was technically true, that the entity signed the document, not him. But that is not a defense to perjury. A subjective belief that a false statement is true can be a defense to perjury if the belief is genuine and the statement is an honest expression of that belief. What this was, however, was a deliberate substitution of a legal fiction for a factual denial. He knew he had been present when the document was executed. He knew his hand had held the pen. The theory was a framework for calling that something other than what it was. That is not an honest expression of a genuine belief. That is the use of a constructed belief to make a knowing falsehood appear to be a philosophical position. The standard was met. The only question remaining was timing. I could have allowed the testimony to conclude, entered the perjury as a separate count, and addressed it at sentencing. This is the more common path. It is cleaner procedurally. It separates the proceedings and allows for a deliberate process. I chose not to take that path. I want to explain why. Because the decision to order immediate incarceration is not one I take without deliberation, and I want the reasoning to be visible. This defendant had been warned, specifically, about the consequences of false testimony. He had acknowledged the warning, dismissed my authority to issue it, and proceeded to testify falsely in the same breath. The warning had not altered his calculation. The oath had not altered his calculation. The presence of the document he denied had not altered his calculation. There was no additional proceeding, no further process, no additional courtesy that was going to alter his calculation. The only thing that remained, as a matter of both law and logic, was a consequence that arrived before he left the room. Not as punishment for arrogance, as the only intervention the record had not yet tried. I recessed the proceeding for 10 minutes. I wanted to be certain, not of the legal basis, which was clear, but of my own state of mind. I have a practice, when I am about to do something consequential, of asking myself what I would think of this decision 6 months from now. Whether I would be able to defend it on the record the way I can defend every ruling I have ever made. Whether I was doing it because it was right or because it was satisfying. I sat in my chambers for 10 minutes. I came back. I ordered immediate remand. I stated for the record the basis, that the defendant had committed perjury in my presence, that I had witnessed the commission of the offense, that the standard for contempt and the standard for immediate detention pending further proceedings were both met, and that given the defendant's demonstrated disregard for the court's authority throughout these proceedings, I had no basis to believe that any less immediate response would be adequate. I stated it plainly. I stated it without particular emphasis. I did not raise my voice. I did not lean forward. I am not sure he believed it was happening until the marshal was beside him. He believed the oath didn't apply to him. It did. He believed the document didn't matter. It did. He believed that if he named the theory precisely enough, the courtroom would yield. It did not. I don't take satisfaction in that. I take note of it. There is a difference, and the difference is something I have had to learn, not something I arrived at naturally. Satisfaction closes a case. Taking note of it keeps it open in the right way, as something that produced a consequence and will produce more consequences in proceedings I will never see, in cases involving people this defendant told his theory to, in the continuing work of whoever is still teaching this framework to people who are looking for a way out of accountability and finding instead a faster path into it. I want to say something that does not typically appear in the coverage of cases like this. This defendant did not construct this ideology alone. He came into my courtroom with a system, a vocabulary, a set of citations, a specific chain of argument that I have encountered in various forms across more than 2 decades on this bench. Someone built that system and handed it to him. Someone told him that federal courts are a game, that judges respond to the right incantations, that the correct legal theory properly invoked can dissolve the authority of a proceeding the way a solvent dissolves a bond. The people who teach this framework are not, as a rule, the people who end up in federal custody as a result of it. They are the people who teach it from a position of sufficient remove that the consequences land on the student. This defendant is in custody. The person who taught him this will teach someone else before the week is out. I ruled on what was in front of me. I want you to sit with what was not. There is a particular kind of silence that follows an immediate remand order. Not the silence of shock. Courtrooms have heard worse. It is the silence of a room in which something has just become irreversible, and every person present knows it, and no one is quite ready to begin the next thing. I have heard that silence many times. It has never stopped meaning something to me. I have spent 32 years on and around the federal bench, and there is a question I have been asked in various forms throughout that time. What does it feel like to be in that room when someone's certainty collapses? And my honest answer has always been the same. It does not feel triumphant. It feels like a specific kind of sorrow, not for what the defendant is about to face, which is the consequence of choices that were made over a long period of time, but for the gap between who they believed they were and what the record shows them to be. He walked into my courtroom believing he had found the key that unlocked the system. He was going to show the system something it had never seen before. He was going to walk out the same way he walked in. He came in carrying a folder. I was already holding the record. That is the only thing I have to say about this case that I want you to carry out of this room. Not the perjury, not the statute, not the immediate remand. The folder and the record. The performance of authority and the thing authority actually is. Because what this case revealed, what it reveals every time I have encountered this ideology in some form across the years, is that certainty and evidence are not the same thing. You can be absolutely certain and absolutely wrong. And a courtroom, at its best, is the place where those two things finally have to meet. I want to propose something to you before we close. Think of someone in your life who has watched a person perform that certainty. The certainty that the rules bend for them, that the consequences apply to everyone else, that the right combination of confidence and assertion is a substitute for accountability. Not a famous person, someone close, someone you have sat across a table from. I am not asking you to go explain federal perjury law to them. I am asking you to carry something smaller. The knowledge that somewhere in a courtroom in this country, a man carried a folder he believed was a weapon and found out it was not. Sometimes that is enough. Sometimes just knowing that the room exists, that it held, that the record survived the performance. Sometimes that is the thing that gets you through the week. Write something in the comments below. Not an argument, not a debate. One thing you want someone in your life to understand about how a proceeding like this actually works. One thing. For someone who needs to know it. I read every one. If what you heard today felt like something you have been waiting to hear someone say directly, the reasoning behind the ruling, not just the ruling itself, I would be glad to have you here. Subscribe, hit the bell. What I bring to this channel is the same thing I brought to that bench for 32 years. The work shown in full, for the viewer who wants to follow it to the only conclusion the reasoning could reach. The marshal stood beside him, and he looked at the bench one more time, and I held his gaze, and I said nothing further. The record was complete. What needed to be said had been said in my ruling, and my ruling was on the record, and the record does not require me to add anything to it. That is the thing about the work, when it is done correctly. It stands on its own. It does not need a closing argument from the person who built it. He came in carrying a folder. He left without it.